Hello everyone, I'm Akshat and today I'm going to talk about the Personal Data Protection Bill in India. Currently as we speak, the Joint Parliamentary Committee has submitted its report which will be tabled in the winter session of the Parliament. The bill is a byproduct of long discussions and deliberations between the government and the relevant stakeholders in India. But before we begin to understand what exactly are the constituents of the bill and do an analysis of the bill, I would like to trace and track the whole journey of the evolution of right to data privacy as a concept and the evolution of personal data privacy bill in India, like the journey of the particular bill in India. So if you try to understand, personal data relates to any information which can lead directly or indirectly to identification of any individual. If I explain it simply, personal data is any information which includes your name, address, telephone number, email address, or anything which relates to your identity. And if I talk about this thing in the digital world, the IP address, which is the Internet Protocol address, it is a kind of address, if I speak simply, which relates to the identification of your device on the internet or on a local server. And similarly, cookies. Cookies are those information which are stored by any website about you in order to make the whole user experience more smooth and easy. For example, storing of login details and password, so that every time you visit over there, the whole experience is more smooth and easy. As per the Personal Data Protection Bill, the major classification of personal information which has been done are the personal data, the sensitive data, and the critical data. If I talk about personal data, it includes name, address, IP address, cookies, and any form of online identifier which leads to your identification. If I talk about sensitive data, it includes biometric data, genetic data, your health, bank and credit card numbers, because these informations are bit more sensitive in nature than the ordinary personal data, and they demand certain extra level of protection while dealing with their processing. And the third is critical data, which the government has stated to be of utmost important in terms of national security or any matter related to the critical defense infrastructure. With regards to the sensitive personal data, it can be collected in India, but it has a provision of being processed even outside. But if you look at the critical data, it can only be processed and collect inside India only. So there's a bar which has been placed by the Data Protection Bill. If I compare it with the contemporary General Data Protection Regulation, that is GDPR, it has only two classifications when it comes to dealing with personal data. Let's move on and look into the major stakeholders which are there in relation to personal data. Before progressing further, I would like to talk about three major stakeholders which is relevant for further discussion. The primary one being data principal. In simple terms, data principal means any person, it can be me, you, or any other human being about whom the data is being collected. The second one is data fiduciary. Data fiduciary relates to any organization, entity, or as the law states, it can be a juristic entity, any state, person, or all of them can be in conjunction with each other, which primarily deals with what has to be done with regards to the particular data. In simple meaning, the data fiduciary is the relevant party which is responsible for deciding what will be done with the data and how it will be done. And then the third one is the processor. Processor is someone who is responsible for carrying out the processing of the data on the guided instruction of the data fiduciary. If I may explain this in a simple example, I give my personal information to Facebook. So Facebook in this particular situation becomes the data fiduciary, and further, when Facebook stores all the data about us on its server, or for example on Amazon servers, they become the processor. So all of this differentiation or classification is important to understand so that we are able to determine the liability in case of a data breach. So let's quickly track the development of right to data privacy as a concept. The concept of privacy gained importance for the first time when an article was published in the Harvard Law Review in 1890 on right to privacy, wherein the author emphasized upon that the private domain of an individual is the foundation for freedom in the modern age, and even went ahead to discourage any kind of intrusion of it. Later in 1948, the Universal Declaration of Human Rights made right to privacy as a statutorily recognized right. But till now, Convention 108 was the first legally binding international instrument which talked about data protection as a concept, and it was adopted on 28 January 1981. But if we look at the contemporary scenario, the General Data Protection Regulation, that is the GDPR, is considered as the torchbearer of right to data privacy. It is one of the most dynamic laws and often considered as the golden standard for data privacy. So one of the major questions which pops up at the moment is, why now? Why do we need a data protection bill or a law at the moment? So the answer can be derived by a careful analysis of the past 6 years or the decade, wherein with the increase in the internet penetration and increase in the smartphone user base, the commodification of data has been on a high. Many experts have even claimed that data is the new oil for which is responsible or which is essential for the functioning of the whole digital ecosystem. I would like to draw an analogy to explain, like the way any fuel is responsible or needed for functioning of a car, like whether it be petrol or diesel. Similarly, data is the oil which is needed to run the car of digital economy. And if you look at the current trends, a lot of brands are using small data points about every individual, or as you call them, digital footprints, to understand the user behavior and then present them with curated marketing material, or which is really suited to their particular demands. So I believe this is the right time to bring a data privacy legislation in India, which not only helps in the upliftment and protection of the rights of the individuals, but also balances out with the innovation and creativity of the society or from the industry. So let's trace the journey of personal data protection bill in India so that we can understand how far it has come from initiation. So in August 2017, the Supreme Court held right to privacy as a fundamental right, with right to data privacy as being an important aspect of privacy. And subsequently, the government in 2018 formed the Sri Krishna Committee, which was responsible for bringing out the draft Data Protection Bill 2018, and it even went on to submit a report to the central government titled A Free and Fair Digital Economy. It was the efforts of the Sri Krishna Committee that we were able to get a bill tabled in the Parliament, which was further referred to the Joint Parliamentary Committee for discussions and deliberations with the relevant stakeholders. And I'm really excited to see that after 2 years of rigorous deliberations and discussions, we'll be having the final report of the JPC tabled in the winter session of the Parliament. A careful reading of the bill suggests that there are major deadlocks or pain points which are present in the bill, which has led to challenging of the bill by the public and the relevant stakeholders. In my opinion, there are 4 major pain points which are really concerning, and I would like to discuss them one by one. The first one being dilution of user rights. The current bill proposes that for any user to withdraw their consent without any valid reason leads to some kind of fees. So charging fees to users for merely exercising their right of withdrawing consent is a regressive provision, because it will discourage the users to exercise their rights in the long run, mainly because of some kind of monetary consideration. Secondly, the processing of data without consent. So the government has been given the power under the law to issue certificates, licenses or permits, or like any kind of delivering of services, and for that purpose they do not need the explicit consent or consent as per. So I feel that a balancing of rights and providing of limited rights to the user in such scenario would help in creating a balance of power. Third is exemption to the employers. Now, this is one of the most concerning provision of the data protection bill, because under this the employers are given complete power to process the data of their employee without their consent. Now, this is disturbing because a lot of things like tracking of employees or any kind of processing which is leads to discrimination can be done by the employer, and that is completely legal. If we look at the counterpart, GDPR, proper consent of the employee is needed for an employer to go ahead with any kind of processing related to the data of an employee. There was a recent example wherein BECIL had put a tender last year to procure monitoring and tracking devices, which was a smartwatch, for their employee. So this is the eventual result of allowing such kind of exemptions. Third, if we move on, is the surveillance. So the government has been alleged many times that giving arbitrary power to themselves to exempt anybody or agency from the provisions of the bill. So the effect of this can be disastrous to the rights of the individuals, because any intelligence or law enforcement agency in this particular situation would have the complete right to process the data of individuals without their knowledge and even their consent. So this hampers the exercise of rights which are given by the law in the most fair manner. And if we look at the last one, is this rights exemptions which are given to the social media intermediaries. So the first one being voluntary verification. Internet is generally considered a space wherein people like to be anonymous and raise issues which they cannot do otherwise in their normal life. So if we introduce the provision of voluntary verification, no doubt it will help in bringing down fake news and other reducing the number of fake profiles, but it will also hamper anonymity to great extent, which will be disturbing in the long run. And the access of online identifiers by these social media intermediaries, or like ID cards, Aadhaar card, etc., leads to large amount of collection of personal information or data points, as we say, about an individual, which can eventually lead to targeting or automated profiling of those of different users, which is against the very tenets of the data protection law and its principle. So I'm very excited and optimistic towards the results of the discussions and deliberations which will eventually take place in the winter session, and I really hope that the government deals away with these deadlocks and challenges in order to make and bring a fair law in front of us. Thank you for your time, and I'll be making a new video once we have the report before us. Thank you.